T SLD dictation speed with 120 words per minute. Start. This brings us to the second question, namely, whether the appeal by the respondent number 1 was maintainable before the tribunal, the tribunal was set up by the state government under section 96 of the act for the purposes of adjudicating appeals preferred under the act, full stop. Section 94, within the provisions relating to appeals, allows any teacher or other employee of a private educational institution who has been dismissed, removed or reduced in rank to prefer an appeal to the tribunal within 3 months from the date of the communication of such order, full stop. There is no argument that the appeal of the appellant was barred by limitation, full stop. The question then is, did the impugned order of the appellant amount to a dismissal or removal within the meaning of section 94 question mark? The impugned order was, as held earlier, not one under or in accordance with the scheme, full stop. The appellant lost sight of the fact that rule 50 within bracket 5 was part of a scheme, full stop, the express object of which was to benefit the employee and not the employer, full stop. The element of voluntariness attaching to the cessor of the respondent number 1's services when the impugned order was passed was entirely lacking, full stop. The result of the impugned order was an immediate cessation of the respondent number 1's services as principal of the appellant's college dehoors the scheme, full stop. We have, therefore, no hesitation in holding that the impugned order amounted a removal within the meaning of section 94 of the act, and the respondent number 1's appeal was therefore, maintainable. Ordinarily, having reached this conclusion, we would have merely dismissed the appeal, but having regard to the submissions made by counsel on either sides, we feel that it would be more appropriate to mold the relief granted by the High Court to the respondent, full stop. The respondent himself had decided to retire for compelling personal reasons, full stop. In fact, he had been on long leave prior to the second notice asking for permission to voluntarily retire, full stop. He had agreed to continue for the time being at the instance of others in the interest of the institution, full stop. The appellant has in the meantime, replaced the respondent with another principal who has been serving for the last 7 years, apparently to the satisfaction of the appellant and without any complaint, full stop. It is also not the respondent's case that the present incumbent is incompetent or has not discharged his duties during this period with dedication and commitment, full stop. On the other hand, the replacement of the present incumbent by the respondent may, given the history of this litigation, create an atmosphere of discord and confrontation which would not benefit the institution at all, full stop. It would, in the circumstances, be in the interest of all the protagonists to allow the present incumbent to continue while compensating the respondent for the incorrect action taken by the appellant against him. We accordingly dismissed the appeal with the direction that the respondent will not be reinstated in service but be treated to have retired from service as indicated in the order impugned before the tribunal, and the appellant shall pay to the respondent a sum equivalent to 3 years' salary as last drawn by the respondent as principal of the college by way of compensation, full stop. Such payment shall be made within 8 weeks from today, full stop. The appellant will also pay the respondent, the cost of this appeal assessed at rupees 5,000 within bracket 5,000 only, stop.